reconvening meeting number 196, and we are picking up with the commissioner update.
Janice.
What?
So we started.
What, did I miss something? I said commissioners, I meant administrative, sorry. Sorry, thank you.
Good morning, Mr. Chair and Commissioners. Harkening back to your discussion on caring health care, in a previous employment, I worked in the Attorney General's office where we figuratively considered access to health care in terms of cost of health care. I didn't realize I'd come to a job where literal access to health care
Right.
would be the next issue. But I will work with staff, Mr. Ziemba, on that. I do consider that a public purpose and an important issue, obviously, working around the constraints of the law also. But the last we left off on the previous meeting, I think the hanging chad, for lack of a better term, was my review. And my memory is that General Counsel Blue described two different processes to do that review, and I will let her refresh your memory. But I'll just say I am truly agnostic. So whatever you choose, I will participate in, but I would like to get that going, and then I could be in sync with pretty much the rest of staff. As I will tell you, I think we are in good shape. Most of our review process for staff here has been done, and we're working through all the other related issues with that.
So when we last met, we talked about two potential options. The first one was for each commissioner to make notes or use the employee evaluation form, whichever they preferred, bring those notes to a commission meeting, have the conversation about the executive director's review, make a determination on salary adjustment if applicable, and then that transcript of that meeting would become his performance review and would be placed in his file. So that was the first option. The second option was having individual commissioners give notes to me. I would compile them into one document. I would present them to you at a commission meeting. You could discuss them at that meeting if you like. You could look at them and then wait and discuss it at a next meeting. In the interim, we have taken a little more time to review a case that came down about performance reviews and municipal boards. The judge in that particular case was adamant that the chairman of at least that particular municipal board could not compile the reviews and then bring it to the board to be discussed. So we know that that is clearly a violation of the open meeting law, but the other two options, and I think either one will work, I think probably complies, and it's up to the commission as to how you want to proceed.
Go ahead.
I think the second option sounds more organized, in which we each prepare and turn it over to you so that you can compile and then report to all of us those thoughts. Just my thought that coming in without, just our own notes might be a little confusing. And this appears to be organized, and we can present to you those thoughts, and you can organize and get back to us. Just my initial thought.
And your compilation would consist of verbatim transcript in some cases, or a summarized notion of the comments?
But I guess it would
Or
depend
does
a
it
lot
matter?
on how you provide them to me. I mean, to the extent that you provide something that's quotable, and, I can put it in there. I would try to set it up in an organized way so that you could see how it fit into each section of the employee evaluation form, so that, but I would also think, too, there may be situations where it doesn't fit neatly into that form, and that's fine, too. That's something that we all grapple with when we use that form for our own employees. So we'll try to get it into an organized document so that way you can see all of the thoughts, and then you can discuss it.
Yeah, and I would think there would be multiple comments that would be similar, so verbatim probably wouldn't work, because I can imagine that we'd each, on some items, there would be the same comment repeatedly. So,
Yeah.
and that, maybe that's reflected in that, 3 commissioners had a similar X thought, whatever.
I think I would not put them in a document particularly, as I'm thinking about it, and attribute it directly to each commissioner. And so to the extent, I think Commissioner Cameron is correct, if I got 3 of the comments, the same comment from 3 commissioners, it would be in there. So it depends on how you want to consider that. If you actually do want to see attribution to each commissioner, it may be better for you to come to a meeting with notes and just, discuss it.
Other thoughts?
Catherine, would there be a impediment to your attaching as basically an appendix to your summary memo, the individual evaluations by us commissioners?
Well, if I give it to you before a commission meeting and I do that, then I am transmitting information between you individually, and so that would be a problem under the open meeting law. If I gave it to you at the actual meeting, then that would be the first time that you were going to see it. That may be different. I don't know that that gives you any time to think about it before the meeting. So, under the open meeting law, I can't transmit information. You can't have staff
Right.
transmit information from one commissioner to another.
What if the individual evaluations became part, I'm just thinking out loud here, individual evaluations from which you were taking your summary were distributed as part of the public meeting package?
And theoretically, if we needed the time, we could finish the performance review 2 weeks later.
Yeah,
Yes.
yeah, basically, you could do that. The public meeting, the package we probably could not give it to you much sooner than the meeting if I'm going to attach your actual notes, because I can't transmit information between you prior to a public meeting. So in that situation, I don't know that you're going to
Okay,
get.
so it's not a disclosure, the issue is not the complying with the notice provisions of the commission's, public business that's going to be discussed. I get
Yes,
it.
yeah.
I'm in favor of the second alternative.
The only issue that I mentioned last week is, in this case, I think it's, the background here is we're all feeling pretty good about stuff, but, if there were issues here, in a more difficult situation, maybe we just do one thing this time, make it clear that we're not committed to doing it the same way in the future. I don't know whether we can do that. But the one thing that concerns me is in the abstract theory is it puts a filter. It puts Catherine actually in could be potentially a very awkward situation, but it puts a filter between us and the feedback. And as I say, in this situation, I don't think there's really probably much to worry about, but as a principle, not having our feedback filtered through somebody else, particularly somebody who reports to the person who's being reviewed,
I don't know that it would put a filter necessarily, because I'm imagining that, the discussion will be just that. With the benefit of the notes, with the benefit of advanced reading, then any one of us has the ability to say, this characterization I entirely disagree with, for example, and here's why. Or this characterization I completely agree, and leave it at that, or whatever it is. I mean, remember, there will be a discussion, and that's the whole
Yeah.
point that's going to follow to this. And the transcript itself supplements, the form that we use, whether it's the same form, which, by the way, I suggest we do, so that just as a guiding document.
Just out of curiosity, what is the difference from an open meeting standpoint of giving us a compilation of what we've all said from giving us what we've all said?
Because if I were to give you a document, and say it was set up and I listed each of your comments and
Right.
attributed them to you directly,
Right.
then I am spreading your comments from one to the other, and that we can't have staff be a transmitter.
But you're doing it
between-
anyway, you're just doing it without attribution? Is that the
Well, I would be
distinction?
giving it to you the day of the open meeting. I would not be giving it to you in
The
advance.
memo?
Yes.
The
Yes, the
So we're not going to get
yes.
the compilation until before the meeting anyway?
Yeah, you're not going to get.
So you
it
might as
before
well
the
attach
meeting.
the raw material.
We could do that.
Yeah, I mean, there's no
we could.
difference.
Well, but my understanding from the training with the Attorney General is that when you have attribution and you distribute it before the meeting, which actually we could do ourselves, you cannot deliberate on that until the next meeting.
A commissioner has to distribute it at an open meeting.
Yes.
I'm not a commissioner. So
Okay.
I have a little bit, I think, based on what the Attorney General said, a little bit more flexibility. We're coming close to a line that, is complicated, and we're trying to do this in a way that, make sure that we comply as best we can. We've had some interesting case law since the Attorney General trained us, which, kind of puts a caution sign up there as to how other munis have done it. But I think, to make sure that we are complying as best we can, the best way to do it would be, if you'd like me to compile it, I can. I give it to you at the open meeting, you take a look at it. If I give it to you at the open meeting, I can do attribution at the open meeting. The question is, do you really want to repeat the same comment 3 times? I mean, part of it is an organizational issue, but part of it is an attribution issue. And then you discuss it at that meeting. You don't have to finish it at that meeting. You can, take whatever time you need to do it. It's not
I
required.
thought, I misunderstood, I thought in the compilation, I thought you were saying you could give it to us in advance, we'd have a chance to read it and think about it. But if we're not gonna get the compilation until the meeting itself, then it seems to me the compilation would be fine, but we should at least attach the originals, so we've got them there. There's no downside to having them there.
Yeah. Other than I didn't realize we were each going to do an evaluation. I thought it was much more along, these are the things that were important to me, and list those things, and that would, maybe reference the category using the list, and then you would compile, which, and if
Well,
we're going to have a discussion anyway, I don't personally see the need for then having these other documents.
Yeah, I mean, you can simply do a discussion, just bring your notes and discuss it, and that's fine. And, based on the notes that come out of the meeting, there can be a form that's completed. If you want a completed form, I think in this situation, the transcript best speaks for itself. So if you come and you have the meeting and you have that discussion, I think that's fine.
It just aids to have that compilation to me, giving our notes to you, you compiling. It just gives us a way to have an organized discussion.
No, I agree with that. I agree.
So you're in favor of the?
I'm in favor of number 2.
Same here.
Same here.
Can we get it in the, can we get it in the morning? We won't have read it, right? We get it when we get our board books, I guess,
Well, you get your board books, hopefully,
a day or two in advance.
a day or two in advance, if we're very lucky.
So
You would get it at the beginning of the meeting. You could take some time at the
Yep.
beginning of the meeting to read it if you wanted to,
Or just take it and then put it off for 2 weeks and pick
Right.
it up.
Yeah,
Yeah.
yeah, you can
All right.
certainly do that,
Yeah.
too.
We'll play it by ear.
Yeah.
Okay. All right, so we'll go, looks like there's a consensus to go for the second option, and we'll see what it is. If it's something we can look at quickly on the spot, we'll talk about it. If it's a big, long, complicated memo, we'll maybe put it off, we'll decide at the time.
Thank you, Mr. Chair, that's all I have.
All right. All right, so the last item.
That will be noted in your employee evaluation.
Last item was a commissioner's update. This is a relatively new item, if not a literally new item, just because I felt, and I think we've all felt, because of the open meeting law constraints, it's important to keep each other sort of apprised of what's going on, and to talk about what would otherwise be sort of administrative things where, in the only environment where we can talk about them. This has now been postponed once or twice, so some of the information that I wanted to mention is out of date, a little bit out of date, but Director Bedrosian and I went and had a briefing session with the Senate and House chairs of Economic Development and Emerging Technologies, our committee, and the Senate's Policy Staff Director, Emily Lockhart. And it was a very good meeting, actually. We forget we're so close. It was really just an update, and, sort of where we stand, what our experience has been, are the signature features of this law, what's happened in terms of jobs and revenue and so forth, how Plain Ridge is doing. But we're so close to it, we forget that even people like our committee chairs, don't really get the details of what we're doing. And I think there were a lot of notes taken. Discussion probably went on for an hour or so. So it was an interesting meeting, and we reiterated to them, as we have to many others, that we got a really good bill, a statute to work with. Anything else on that was worth noting?
No, I just, given where they were in their session, I was impressed by the amount of time they gave to us.
Yeah, right. They were at the very end of their session. The second thing is we have G2E, which is the big American Gaming Association annual conference coming up. It runs from Monday, September 26th to Thursday, September 29th. Preceded by a day for problem gambling. I guess it's the NCRG Problem Gambling Conference. I do intend to go. I'm going to be on a panel out there, but we need to think about who else. I mean, each of us is kind of thinking about areas of focus and so forth. And we have, on one hand, we have to be a little bit, discreet about how many people go where and how much money we spend. On the other hand, there's a lot to be learned. There's a lot going on out in this industry. And we're still in a very steep learning curve. So I just wanted to remind everybody, we ought to make those, if you're interested in going, let me know, and let's try to work it out.
I would like to remind ourselves that the travel budget is, as many other items in the budget, is slightly lower on a number of fronts. And by the same token, I agree entirely that it's important for us to continue to have some presence, not some presence, understand trends, understand a lot to learn. In not just G2E, but there's a number of other conferences, IMGL, IAGRA, problem gambling, etc. So as a general sort of comment, I guess some of the numbers that were included in the budget assume a little bit of the following, which is very sensible in my mind, that a number of people, a small group would go to these conferences on a sort of rotating basis. It's important that somebody see G2E for the first time, I think. And some of us that have seen that before maybe can take a pass to allow others. I know Commissioner McDonald has never been there, and it would be a great opportunity as others, even others that have been here for a number of years, like Director Wells, or of course you've only been here 9 months, but Director Petrosian. So if we rotated, having some presence, we don't have to have a very large group, and out of that process, we look at making sure that people that legal have a presence, and maybe you all can decide who is it this time around, or others with a technology background and interest, and each of these groups are sort of multidisciplinary in a way, but it's a small, manageable group. I think that would be very important. I know we're not just talking about ourselves, commissioners, but more the staff.
Both. I mean,
yes.
Yeah, I was speaking just about us, and assuming Director Petrosian is going to be wrestling with the staff issue, but the same thing goes.
Right.
Right.
And something else which may go without saying, but just having a conversation with people who have been out there, for example, is extremely valuable, maybe extremely valuable, as in, what did you find useful making an appointment with a certain, slot machine manufacturer, for example, seemed to me extremely helpful last time I went, because it's easy to get lost in the massive showroom that G2E can have. And if there's a small group that's going to go, well, that much better if there's a few that can go to those kinds of appointments. The round table that AGA puts together, or that GLI puts together, also invaluable, so that people can make the most of it. That would be my only other comment relative to that.
Yeah. So both for substance reasons, equity reasons, and budget reasons. We just sort of think about which ones you're interested in doing. We've already, I think Commissioner Cameron has got some areas that she's already focused on and she's interested in it. So just let me know what you're thinking about that, so we can sort of do this a little bit organized. The only other thing was back in May, went to the East Coast Gaming Conference, which was held in Atlantic City on May 25th and 6th. Again, I was on a panel. It was heavily on online gaming issues. We hope that the legislature will have passed a statute to set up a study commission, not just on DFS, but on all online gaming. Senator Flanagan, who had the online lottery legislation, didn't know whether either hers or ours would pass when I saw her on Saturday. But we're hopeful that we will have a study commission that we will be a part of to help do the background work that we recommended in our white paper, that we look at the whole panoply of online gaming stuff. And that this would be a legislative commission that we would be a part of and give them the tools maybe to try to come up with legislation next year. So this, a lot of the things talking about at this conference was very relevant to that. Just a few data points. 30 to 50% of gaming revenues in Europe are online. Less than 1% in the US. So it's just coming. All the evidence is, this is something you've said all along, it's coming, it's coming, it's coming. E-sports, which most of us don't even begin to understand yet, generate $7 billion in revenue, which is internationally, which is the same amount of money that Las Vegas generates in gambling revenue. So that's one whole huge issue. There's others, but the data points are kind of interesting. Both New Jersey regulators and New Jersey operators have had more experience on this than pretty much anybody else. They have a lot to say, and I think we can learn a lot from them. And if we do have our study commission, we might involve them in that a little bit if the legislature's okay with that. The other topic that came up a great deal was the challenge of attracting the millennials to bricks and mortar and traditional casino gaming. We've heard about it many times. Out of that came some things that I think that we need to think about proactively, and I think maybe we want to think about getting Justin working on some stuff. Do we have any role in pushing the promotion and development of social and skill-based gaming? We're in a reactive mode at this point. That's fine. Should we be more proactive on that? If that appears to be a significant way to attract a younger demographic, do we have a role in that? I just put it out there to think about it. There's a tremendous amount of work going on about floor design to promote social interaction, which is a more attractive kind of gaming to millennials. Supposedly, Mandalay Bay and the Downtown Grand are doing a lot of floor design. I assume our licensees who are developing these new facilities are also being attended to this, but again, do we have any role in just at least thinking about this, being aware of it? And finally, for sure, expediting approval and deployment of new and innovative games. I think we definitely do want to be in a position to expedite, and if we judge, to approve on a quick basis, so we can be at the forefront of constructive innovation. I also, on June 6th through 10, went to Las Vegas for the conference on gambling and risk-taking, which is a somewhat esoteric conference put on by the UNLV Institute on Gaming. Wynn gave the opening address, and this was, I've probably heard some of this before, but Bugsy Siegel opened the Flamingo in 1946. That was the start of Las Vegas. The Mirage was the first integrated resort casino that opened around 1990. From 1965 to 1989, Caesar's Palace had $400 million of gross gaming revenue, which was considered the ceiling at that point for almost 20 years. The Mirage hit $500 million in gross gaming revenue and $600 million in non-gaming revenue. First time that non-gaming exceeded gross gaming. Bellagio opened with $600 million in GGR, which was considered the ceiling, and $800 million in non-gaming. Wynn then followed with $700 million in GGR and $900 million in non-gaming. Encore now has $840 million of GGR and $1.1 billion in non-gaming. So the relationship between the two is expanding, but gaming revenue is still going up tremendously. What's the ceiling for a Las Vegas casino has doubled in the last couple of decades. Interesting conversation about data mining. We know about this stuff. We have a mandate to use our player card data, but they raised a bunch of issues about things I never even thought about before, which theoretically there could be a relationship between real-time play, which the casino operator can monitor, and what's going on the floor. Theoretically, you could notify your casino employee on the floor and say, hey, Mr. Smith is slowing down his play, you might want to go over and give him a drink, I don't have any idea whether that goes on, but it could go on. And it's just something to think about. There's a few other issues having to do with responsible gaming that I have already talked with Mark about that I think we want to look into. An issue was raised both at the Nickel-G's conference that I attended and panel I was on Saturday, and was raised out here in Vegas, which is the issue of duty of care. And I was thinking, Director Bedrosian and Catherine, that I don't think this is anything we've ever really talked about, you know. Is there a duty of care for our licensees? Should there be? Do we have any role? What do we think? So, I mean, I was thinking about just asking you guys to sort of probe around in that and give us some thoughts as to what, if any, role, relationship, significance, import there might be. There's apparently been a recent.
West Virginia, I think
West
was it.
Virginia
Yeah, I
decision.
was at that conference
Yeah,
also and
right.
thought the same thing you did, so I
Okay.
contacted general counsel on that. I suspect there's nothing on this because gaming's so new in Massachusetts, but we will look at that.
Well, and what should there be
Yeah,
is,
the phrase duty of care, it's a phrase of art in the law of torts. What is it, what's the context that has arisen here?
Duke, do you want to?
Yeah, so the context was, Commissioner McDonald, that it was brought at the conference that the chairman and I were both at up a couple times. The West Virginia Supreme Court has issued a recent decision in the last, I think, couple months stating that and I'm going to paraphrase, and rule against hearsay applies if I misquote what it was. What I heard was the West Virginia Supreme Court issued an opinion stating that the casino industry in that state does not owe a duty to care to its customers. Yeah.
Oh, they
so-
do not.
As to their economic loss on.
Yeah, I would assume
being
so,
public
but we are
interest.
going to look at that
I
case.
see, okay.
It's
And it
like,
was,
like a bartender.
Okay.
Yeah, kind of issue. And it had come up, before I heard it at this conference on Saturday, I'd heard it out in Vegas too. So it's just an interesting thing that I think we ought to be aware of, ought to be thinking about. The other thing that came up in the online gaming and the esports was all this skins betting. There's this phenomenon of skins betting, which is basically betting on things going on within the games, not the outcome of the games themselves. Infinite permutations. In your book, I've attached 4 articles that I came up with that are sort of about some of this skins betting stuff and some other related issues that are just interesting. Last thing, and this occurred to me while during these sessions, that we ought to think about, or do you think we ought to think about, whether we would want to give some kind of awards, have the commission give certain kind of awards for things to our licensees or others for things like best gaming innovation, best responsible gaming activities, diversity accomplishment, revenue per machine, or any other key metric that we want to promote. I mean, we could have an awards session where we give our licensees or other constituents recognition for doing the best job that year in areas that we care about. I just throw it out there. I'd be interested in having you guys think about it. I might bring it up at the next meeting, see whether you think it's anything we ought to look into. I don't know whether anybody does it. I think it'd be kind of interesting, kind of fun, and it's a way to promote and reward good behavior. So, worth thinking about. And that was pretty much it. That's it for my commissioner's update. Do any of you have any other?
Can I react to a couple of points?
Yeah,
I did
please.
have an update. Well, the update I wanted to give is on I attended the National Council on Responsible Gaming Conference in Tarrytown. I was part of a panel along with Mark and Marlene Warner and a GameSense advisor on the GameSense program. And 2 things very quickly. The first one, the topic of skins is one that the industry, in this case, the association and service providers and whatnot, but also the industry, is looking at as well with a lot of interest, because the nexus to esports, which is also exploding, is very important. This could be a way to bypass gambling statutes, if you will, in different states, where the stake is indirect enough to be able to call it not gambling. And again, something to keep an eye on. But more importantly, from that conference, and I realize this is going to sound very self-congratulatory, but with that
for us.
preamble, for everybody here,
all right.
for everybody here, us especially, we are really regarded very highly when it comes to responsible gaming by the national problem gambling councils and others. We met a delegation. I'll give you a quick example. We met a delegation from Singapore who came to that conference, and they came and met with Ed and Mark and myself as a follow-up to that, because they really wanted to understand the progress and the evolution of what we've done in this area. Very interested in understanding Play My Way, how that came about. They went to go see it being demonstrated. The Game Sense Center and the Game Sense program was also very much in their interest. And they told us in no uncertain terms that they thought of us as the gold standard when it came to this area. They were equally impressed by our transparency and our open meetings, by the way. But that was not really what they were here for. And it's one thing to sort of hear it anecdotally, but quite something different when people come out after a presentation like the panel I did, not just them, but others, and talk about how the factors that influenced it, the law, the regulations we've done, and a number of other things. And that was also very important to hear, and wanted to pass it along.
Great,
Good to know.
yeah.
Along those same lines, we talked about skins. When I attended a conference on illegal gambling, there was a whole presentation on sports betting, and that piece of it, the in-game betting, has exploded in Europe with mobile, the ability to use a mobile phone to place bets. So the in-game betting has just exponentially made that business grow tremendously. Will they make the field goal, the game-winning hit with the bases loaded? All that in-game betting has really changed sports betting because of the ability to place those bets during the game with a mobile phone.
And is that the definition of skins? Is some kind of a within-game bet?
That's
Yeah.
one of the terms. There's a
Yeah.
number of terms used for and one of them just being, in-game betting. But that has changed sports betting tremendously.
The articles that I have put in here do describe something to help you understand it, but I think it's evolved.
I actually read them but didn't understand.
Well, me either, yeah. But it's evolving so quickly that, you can't keep up with it.
And that's the point, that there's been any number of games that, in the non-gambling arena, and the explosion of games is remarkable, mobile and, that millennials like, et cetera, that trying to regulate the game, just much like this, that was the centerpiece of our white paper, is perhaps misdirected, that there needs to be a more holistic view of what it means to risk money on any platforms, and what are the components of the activity, and why it needs to be regulated, rather than trying to chase the legalities of DFS and why now that needs to be thought of one way or another. There's nothing wrong with that, by the way, but there's going to be any number of permutations that can easily surface all of a sudden. I mean, look at Pokemon Go and the explosion of this
Yeah.
game. Now everybody seems to be
Yeah.
needing to play.
Agreed, and along the lines of public recognition, as you just spoke of, I also sat on a panel yesterday at Nickel G, and it was a master class for IMGL, and it was a panel discussing the sweet spot with regulators, with licensees, with legislators. And we, unexpected to me, a couple of the gaming attorneys gave us great credit for our educational forums two different individuals that I knew one of the two. And just how that's very helpful to legislators, to have that educational piece, because they do not have the time on their own. They're making decisions about gaming without proper information. So that was something that folks thought that we did really well, the educational forums and the white paper. And the other thing that I didn't necessarily expect was the chairman here of the Wampanoag Tribe Gaming Authority, Gaming Commission rather, gave us credit for being, he said he's worked in a number of states, and the relationship with the commercial gaming authorities has not been strong. And he really gave us
Between the
credit.
tribal and the commercial.
Correct,
Yeah.
for welcoming him, bringing him to our offices, introducing staff, just being overall helpful to another gaming commission, recognizing them. So that was also just nice to hear that someone thought that, and there was a lot of tribal conversations yesterday, so that was along the lines of, you're right, Commissioner, but just things that we're doing as a team, that's the entire staff, right, that welcomed that group. So just some interesting things that were discussed yesterday.
I just want to say this is a great addition to our agenda. When I was on a 5-member school committee, we would go through this kind of the beginning of every meeting to talk about different things we'd been hearing about and witnessing as we went out and about in the community. I also had a chance to go to the Nickel G presentations. I think some of the interesting ones, there were sports betting, esports, pari-mutuel betting. I sat with a gentleman from the horse racing industry at lunch. He said, we need to make it easier for people to understand how to bet on horses, what all the information and all the scorecards means. They need to do a better job at that. We all had, Commissioner McDonald and Chairman and I had a chance to participate in the dedication of the new MGM culinary training facility out in Holyoke. MGM is fronting some money for the operation of the facility, giving some money up front to the city of Holyoke so they can help out about 50 individuals to go through the culinary training program. We have had some additional follow-up after our workforce skills cabinet meeting with some key point people from education, housing and economic development, and labor and workforce to think about next steps. MGM has invited Director Griffin and I and these 3 individuals to come down and see their training center at National Harbor to understand what they hope to replicate in Springfield. Commissioner Zuniga and I and Director Griffin went to a vendor diversity summit that the Governor's Access and Opportunity Committee pulled together that had SDO, Massport, a number of other agencies at the table trying to think about best practices. We're going to host the next meeting here at our facilities. And I also listened in on Justin actually did as well, a webinar on esports. And one of the interesting takeaways was they had the property manager from the Downtown Grand in Vegas talking about introducing this into their facility and great recommendations in terms of don't make it look like it was an afterthought. Don't look at like, hey, we got an extra storeroom, why don't we turn that into our esports gaming area? They talked about the margins in the business is not that great, but they hope to your point, Mr. Chairman, about non-gaming revenue, get people in, get them to play, and at the same time, hope they patronize the food and beverage side of the house while they're there. So,
Yeah,
interesting stuff.
great. Anything else?
Yeah, I might, since I'm the only one who hasn't said anything, this doesn't qualify of having gone to an event other than I did find the opening of the culinary facility in Holyoke really inspiring. I thought that it was really a great demonstration of the combined combined partnership between one of our licensees and the city of Holyoke and the city of Springfield. But, I mean, while we're here in open meeting, last week when I was on a couple of days off, I had my quiet time interrupted by an email from our executive director, who was passing on to me the decision from the federal court here in Boston with regard to the Taunton Citizens litigation. And you've undoubtedly already, heard of the outcome, in which Judge Young had concluded in very emphatic terms, including the phrase, "This was not a close call," that the land and trust decision by the Department of Interior of the Mashpee Wampanoag tribe was fatally flawed. And the nutshell of that conclusion was based on the Department of Interior's Bureau of Indian Affairs Secretary's reliance on the second category of definition of Indian under the so-called 1934 Indian Restoration or Reorganization Act. In any event, the 1934 Act. And within 24 hours, my piece was interrupted again by Executive Director Bedrosian forwarding on to me a decision of the Court of Appeals for the District of Columbia Circuit, Federal Circuit Court of Appeals, deciding a challenge to the 1934 Act that was raised with regard to the Cowlitz tribe of Washington State, having been granted land in trust under the first definition of Indian in the 1934 Act. And I know that all of us, to one degree or another, are aware of the so-called Carcieri issue, and the Carcieri issue arose out of the decision in the late 2000s, in which the Supreme Court, by 8-1, found flawed the record of decision of the Department of Interior and Bureau of Indian Affairs with regard to the Narragansett tribe's land and trust. And the Carcieri issue has been raised at the outset of certainly my time on the commission with respect to the Mashpee Wampanoag application, not application, the Mashpee Wampanoag land and trust and presently being executed casino plan with their partner, the Genting organization. So the question is, what does this mean for the Mashpee? What does the Cowlitz case mean for the future of the federal court litigation here? Even standing by itself, what is the prospect of the federal court litigation here that was decided by a federal court decision decided by Judge Young? I'm certainly not in a position to give any guidance on this. We're looking forward to analysis from our general counsel and Indian specialist attorneys that the commission apparently has had a relationship with for a number of years. But that just a couple of comments. Number one, Judge Young did in effect certify his decision for expedited review by the First Circuit Court of Appeals, so that it's going to be interesting to see what in fact that expedition is comprised of. But this is not something that's just been kind of left there to go through the ordinary course. The second question that I would think that each of you would be interested in is what, my sense is, just on a preliminary basis, of the relationship between the Cowlitz decision from the D.C. Circuit and the Taunton Citizens litigation. I can say a couple of things. Number one, it's important to understand that the Taunton Mashpee Wampanoag record of decision was based on the judge's construction interpretation of the second definition under the 1934 Act, so that even if the Mashpee Wampanoags had been proceeding under the first definition, like the Narragansett tribe had in the Carcieri situation, then if that were the case, the D.C. Circuit, which has great influence on Indian law issues, a decision would have a very substantial likely impact. But it's the second definition. So the question is going to be, what is the First Circuit going to do with the second definition in light of the D.C. Circuit's construction of the first definition? That one, I wouldn't even give a preliminary opinion on, but that it is important to know that the District of Columbia Circuit found the two very significant phrases in the 1934 Act, namely, what does it mean to be what does reservation to mean, and what does under federal jurisdiction mean? They found those terms in the 34 Act to be ambiguous, and which is contrary to what Carcieri had decided with regard to what's the meaning of the word now. And in a famous line from Justice Thomas's opinion for the court, that now means now, 1934. That the Carcieri decision seemed to imply, and I think that Judge Young, it's fair to say that Judge Young thought it did as well, that those statutory phrases that were not ambiguous, but even if they ultimately, or in some kind of objective sense, were thought now in light of the D.C. Circuit's Cowlitz opinion to be likely to be ambiguous, that wouldn't directly apply to the Taunton plaintiffs' litigation
Except it would-
in the near term.
In the near term.
In the near term.
Given-
What it could do is then just lead to
Another
to
one.
another application, but they might have to go back and start all over again.
Thank you. Are we finished?
Yep.
I was going to bring that up as an item of business which was not anticipated when we put together our agenda, because it was decided on Friday after we had put together our agenda, Thursday, I guess, after we put together our agenda. Thank you for explicating something which is virtually incomprehensible. It's in the nature of the racing legislation, if you ask me. But people have been asking. I know Elaine Driscoll has fielded a lot of inquiries. So what are we going to do next? Now, what does this mean? And from my standpoint, the issue we've always been wrestling with from Region C was the tribe going to get land in trust, and how long should we wait for that to get resolved? And we wrestled with that, made temporary delays, and eventually decided, all right, we can't resolve that. Let's go ahead and do the commercial process. Now we are right back to where we were, which is the tribe going to get land in trust? And if so, when would that be resolved? So we are dead smack right back where we were, and I think think at this point, and I think this is what the staff is recommending as well, is that for the time being, we're just gonna sort of sit tight. And we've always said that a major variable in our Regency deliberations is the status of the tribe. The status of the tribe is now in play yet again. So we'll just, for the time being, let some time pass and see if this begins to sort itself out in a way that would inform future action for us.
And Mr. Chairman, we've, not surprisingly, staff has been contacted by a lot of stakeholders in this case who are sharing their particular views of the either strength, weakness, success, or lack of success. But I think the best staff can do at this point is gather as much information as we can, understanding the context of, we are very early on in this process.
Yes.
So,
Well, and that is a good, and that's, I think, great. The issue, as we've always wrestled with, is where on the one hand, we have a wish for some kind of certainty so we can make an informed decision about a commercial application, on the one hand, but on the other hand, there are interested parties in southeastern Mass who want the benefits of a casino, whether it's the revenue or the jobs or just simply the pleasure. And we need to be attentive to that as well. So, and you as well, if you've got any guidance for us along the way, we're certainly looking for it. But at the moment, I think we just have to sit tight.
Let me just say one final thing to correct something that I said. I didn't have my glasses on when I was looking at my notes. The phrase of art, the two phrases of art from the first definition under the 34 Act is accurately, I said before, under federal jurisdiction. But the second phrase of art is not reservation, it's recognition. So it has to do with the recognized status of the tribe as of 1934.
Okay, the only other item that's come up that wasn't on the agenda was our next meeting. It looks like we have decided on Wednesday, the 10th, will be time to be determined. But at that issue, we will deal with, hopefully, the remains of the racing decision-making and such other interesting and new projects that come up between now and then. Anything else, anybody?
So that next meeting is going to be on things other than the.
Well, it could be.
today.
I mean, since we're having the meeting, if things come up, we can
Okay.
put it in there, yeah. There's no plan to at the moment, but things have a way of coming up. Do I have a motion to adjourn?
So moved.
Second?
Second.
All in favor? Aye.
Aye.
All opposed? The ayes have it. Thank you all. Thank you, Commissioner Cameron, for sticking with us. I think we should go home and go to bed.